remember, this is the judge. He's going to cite this U.S. Supreme Court case, which says Trump is doing it right. It's a political question. The judge can't question Trump's political judgment. And then he's going to say, yeah, I have the Supreme Court here saying Trump is right, but I'm going to go with this left-wing Trump derangement syndrome, unelected black robe, tyrannical inferior trial court judge who's making current lawfare rulings against Trump and elevate that loony judge's opinion above that of the Supreme Court. So here's the Supreme Court, their argument. In this case, Martin v. Mott. It had to do with a militiaman who did not want to enter federal service, and President Madison had ordered the New York militia into federal service. The statute said, whenever the U.S. shall be invaded or in imminent danger of a foreign nation or Indian tribe, it shall be lawful for the President of the U.S. to call forth the militia of a state as he may judge necessary. The Supreme Court decision of Martin thus presented the question, is the President the sole and exclusive judge whether the exigency has arisen, or is it to be considered as an open question upon which every officer to whom the orders of the president are addressed may decide for himself, and equally open to be contested by every militiaman who shall refuse to obey the orders of the president? The Supreme Court held that the authority to decide whether the exigency, whether the condition, and remember, under 12406 here, there are three alternative conditions, and Trump found that two of those exist. The Supreme Court held that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons, including judges. It stated, the Supreme Court, that the president is necessarily constituted the judge of the existence of the exigency in the first instance and is bound to act according to his belief of the facts. And so the Supreme Court concluded that whenever a statute gives a discretionary power to any person to be exercised by him upon his opinion of certain facts, it is a sound rule of construction, statutory construction or interpretation, that the statute constitutes him the sole and exclusive judge of the existence of those facts. So the Supreme Court says these political questions involving the militia, the president makes a decision about whether or not the condition has been met, and it cannot be second-guessed. It cannot be second-guessed. That's what the Supreme Court says. But wait, Judge Charles Breyer of San Francisco says, there's another case here, JAV versus Trump. Guess what JAV means? It means this is one of the illegal migrant third world invader cases that these federal judges allow these criminal migrants to file in their courts using their initials. So we can't discover that they're just another Khalil Armando Abrego Garcia, another MS-13 terrorist, another human trafficker, another spouse abuser. It's utterly contemptible. These people, these judges are fighting to keep in our nation. This is one of those cases, JAV versus Trump. And the question in that case was, well, the Alien Enemies Act says that if these conditions are met, if there's a predatory invasion, for example, the president makes that call. But the federal judges here can't stand that. They can't allow the president to have any core and plenary power. So in JAV versus Trump, the court said, no, it's up to me to decide whether the predatory invasion the president claims actually exists, the predatory incursion. So the federal courts here are saying, no, the Alien Enemies Act says the president makes that call, but we're deciding, the Article 3 judicial branch is deciding that if any one of us 733 unelected, black-robed, tyrannical, inferior district trial court judges disagree with the president's opinion, we can stop him. We can order him to stop. So obviously what that means is the president is powerless to do anything unless he gets the approval of every one of the 733 unelected, black-robed, tyrannical, inferior federal district trial court judges in the United States. They are a super legislature, more powerful than Congress. And who elected them? Not a damn single American citizen. That's who.
Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
Another facet of this opinion, this temporary restraining order by Judge Breyer that is really contemptible, is that he's obviously basing his ruling in part on his personal dislike of what Trump is doing in terms of immigration law. Here's an example of that. The judge writes, because one of the things Trump had argued, one of the conditions Trump said was met for the activation of the National Guard is that ICE is being made unable to execute federal law, federal immigration law, because of these thousands of rioters, looters, arsonists, rebellious, domestic enemies, as well as illegal migrant third world invaders. These circumstances have made it impossible for ICE to carry out their lawful detentions of these illegal migrant third world invaders. And the judge says, well, I don't know about that. Not in my opinion, the judge says. And he writes here, whether ICE could have detained more people in the absence of the protest is mere conjecture. In other words, Trump is saying, listen, these protests are making it so my guys can't do their job. And the judge is saying, well, we don't know that. We don't know that. We actually have statements from ICE saying, no, we were unable to execute this raid. We were unable to execute this warrant. We're being impeded and obstructed from doing our jobs. And the judge is like, but I don't know that. We don't really know if you would have been able to do a better job without the riots. The judge writes, even assuming that Trump is correct, the statute does not allow for the federalizing of the National Guard when the president faces obstacles that cause him to underperform in executing the laws. And what the judge is referring here to, of course, is that the White House has announced they have goals like 3,000 deportations a day or 3,000 detentions a day. And the judge obviously, viscerally holds those goals in contempt. And he says, well, if the riots are preventing you from hitting your goals, that's not the riots' problem. You, Donald Trump, are just underperforming, you pathetic loser. Just do your job better. Don't blame the riots. The whole reason Statute 12406 exists is for when the president cannot do his job because of riots. Unbelievable. The statute does not allow for the federalizing of the National Guard when the president faces obstacles that cause him to underperform in executing the laws. Nor does the statute allow for the federalizing of the National Guard when the president faces some risk in executing the laws. Though, of course, federal employees should never have to fear danger when performing their jobs. How are they not fearing danger? They're having bricks thrown at their head. They're having chunks of concrete thrown through the windows of their moving vehicles. They're being impeded and obstructed by numbers of riders vastly exceeding their own personnel. They're being literally threatened with death, not just their own death, the death of their wives and children and mothers. The judge says the statute requires the president to be unable to execute the laws of the United States. That did not happen here. Really? Nowhere was ICE unable to execute the laws. Completely contemptuous. And now we get to the end. So, a few things that are really egregious about how this TRO was issued. First of all, most of these TROs, temporary restraining orders and preliminary injunctions that have been issued against Trump, have not technically included Trump as a defendant. Because when they do that, they run into obvious separation of powers problems. How does an Article 3 judge have the authority to enjoin the Article 2 executive branch president? He doesn't. So what all these judges have been doing is saying, well, I'm not enjoining the president. President Donald Trump is not included among the list of people I'm enjoining. I'm enjoining instead everybody who works for Trump. Now, is that a difference with meaning? Not substantively. Obviously, Trump's not out deporting people. He delegates his executive authority to his subordinate officers to do those jobs. So when you enjoin the subordinate officers, you've effectively, obviously enjoined the president. But they do the smoke and mirrors where they say, well, we just won't include Donald Trump in the list of people enjoined, and therefore we're not violating the separation of powers. It's ridiculous. But nevertheless, that's what they do. They leave Trump's name off. This judge did not. This judge kept Trump's name on this order as one of the defendants, and therefore when he writes the defendants are enjoined, he's including President Trump. He's claiming for himself, an unelected black-robed, tyrannical, inferior district trial court judge, the legal authority to order about the Article 2 executive branch president himself, as if that president, elected by the whole of the people to carry out our political will, as if that president were a mere clerk in Judge Breyer's court. The arrogance of these judges is unbelievable. So he enjoins the president from deploying members of the California National Guard to Los Angeles. He directs, orders that the commander-in-chief of the United States hand over authority over those troops to the feckless Governor Gavin Newsom of California, who's allowing Los Angeles to be rioted, looted, and arsoned to the ground just so he can protect the presence in his state of tens of millions of illegal migrant third world invaders. Governor Gavin Newsom obviously has no interest in defending LA against these rioters, looters, and arsonists. And this last line, a couple issues here. I forgot about this one. So in the oral argument yesterday, at the end, the Department of Justice went to the judge and said, Your Honor, if you're thinking about issuing an injunction against us, against Trump, we only ask two things. First, we ask that you don't make it a temporary restraining order, make it a preliminary injunction. And the reason they asked for that was that technically, a temporary restraining order cannot be appealed to a higher level court. Just can't be done. Not allowed. But obviously, this would need to be appealed right away. a preliminary injunction can be appealed. So a temporary restraining order is temporary, 2 weeks. And then it can transition into a preliminary injunction, which is durable, lasts for the duration of litigation over the case, litigation on the merits of the legal arguments. A preliminary injunction can be appealed to a higher court. A TRO cannot. So the Department of Justice says, Your Honor, we only ask that you don't make it a TRO, make it a preliminary injunction. So we have the option to appeal it. And if you do issue a preliminary injunction, give us a week to appeal it. Stay it, issue your order, but then pause your order for a week so we have an opportunity to pursue an appeal. This is what the judge did. He didn't issue a preliminary injunction. He issued a TRO, which fortunately the Trump Department of Justice had the balls to treat as if it were a preliminary injunction. They obviously did appeal it, but he made them take that extra step. He deliberately issued it as a TRO instead of a preliminary injunction, and then he paused it for a week to give the Department of Justice a chance to appeal this ruling? No. The judge paused it for 3 effing hours. 3 hours. From 9 a.m. when courts open this morning until noon. The judge said, all right, I'll stay my order. You have 3 hours. MFR. The arrogance of these judges is unbelievable. Unbelievable. And he has the gall to waive the Constitution in the face of that very skilled and talented Department of Justice lawyer who argued on behalf of Trump in his courtroom. Just contemptible. The last part of this that was just so egregious. So there's a rule of civil procedure, and this is not a criminal case, obviously, it's a civil case. It's called Rule 65, and it governs how injunctions and restraining orders are issued by federal courts. And there's a whole bunch of hoops that have to be jumped through and conditions that have to be met. But here's the portion I wanted to discuss. So this is Rule 65. This is paragraph C. So it's Rule 65C. And it says the court may issue a preliminary injunction or a temporary restraining order only if the party asking for it gives security in an amount that the court considers proper to pay the cost and damages sustained by the other party if it turns out the preliminary injunction or the TRO was wrong. So between normal parties, of course, I sue you in federal court, and you're about to, tear down a building so you can build a shopping mall, and I get a temporary restraining order against you. That other party, your mall, you the mall builder, you might say, Your Honor, I'm going to have contractual costs if I can't build the mall on time. If it turns out that the injunction you're giving this guy was wrong, it was wrong to issue it, I want him to put up a bond to cover my damages that I'm going to experience. Rule 65 says that's required. It's non-discretionary. It says the court may issue the injunction only if the party seeking the injunction puts up a bond, gives security in amount proper to pay the costs and damages if it turns out the injunction was wrongly issued. There's nothing discretionary here. The injunction cannot be issued unless the security is provided in an appropriate amount. So what's the appropriate amount for violating the core and plenary powers of the Article 2 executive branch of government? It's probably infinite, right? In my opinion, but it's certainly worth something, right? There's some value under the U.S. Constitution to having a functional Article 2 executive branch that's not being wrongly enjoined by an Article 3 unelected, black-robed, tyrannical, inferior district trial court judge. That's worth some value, right? I would think to protect and defend our constitutional order, the same damn oath this judge took when he took the bench was to defend the Constitution against all enemies, foreign and domestic. And this judge says, oh, you know what? 65C, huh? I'm supposed to require a bond. Huh? I'm supposed to require security. You know what? I'm not going to ignore my duty under the law. I will require a bond. Look at that last line highlighted. California is required to post a bond of $100. $100. That's the value this judge places on having a functional, integral Article 2 executive branch of government under our constitutional order. $100. When one of these rioters, looters, and arsonists throws a chunk of concrete through the window of a nice vehicle, you think the damages already are more than $100 just in property damage? Set aside the separation of powers violation. What a piece of judicial garbage this judge is.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.